So we've got a lot to cover here. We're going to start off with something that was old news. It should be comfortable for you, not too scary. Something you already heard about. It was the Families First Coronavirus Response Act. So this was out. This was part of the big congressional CARES package that was passed basically last April. And it is a law that required you to pay leave under certain coronavirus circumstances to your employees who had to stay home because of a coronavirus situation. There is a relevance going into 2021, which I will cover for you, but just as a quick reminder, we'll go through the categories quickly because this all should be old hat to you at this point. It required any employer with fewer than 500 employees to provide emergency paid leave to any employee who was subject to a federal, state, or local quarantine or isolation order, who had been advised by a healthcare provider to self-quarantine related to COVID-19, who was experiencing COVID-19 symptoms and was seeking a medical diagnosis, who was caring for an individual subject to an order to stay home or to quarantine, to isolate, or who was had COVID symptoms and was required to stay home, or who was caring for a child whose whose school was not available or nanny was not available because of COVID-19. And then this last number 6 has still yet to come up, but it basically allowed the possible designation of other conditions as being the same as COVID-19. If you had an employee that fell into one of those categories, you were required to pay up to $511 per day, their regular rate of pay, basically for reasons 1 through 3. That was up to a 2-week period based on their regular work schedule, right? And for $200, up to $200 a day for reasons 4 through 6. Again, we've never had a 6, but basically if you're staying home to take care of your child. Furthermore, that reason 5, staying home to take care of a child, would allow you to stay home for up to 12 weeks of paid leave for a maximum payout of $12,000. The usefulness of this statute was that you had the ability to recapture the money paid out through your quarterly payroll tax credit. You get a tax credit against your payroll at the end of the quarter, your federal payroll. Anybody that had the leave was available, could use any paid time off that they had and potentially get a higher rate if they're paid more than the $200 or the $511 per day. They couldn't be forced to use the PTO, but they can if they want to, and if they do, it's one or the other. You don't get to stack the benefits. There were additional laws that were passed in California, San Francisco, and as a state, we passed some laws dealing with food sector employees because Congress had limited this law to fewer than 500 employees. And that kind of didn't make a lot of sense to some of us. And so we implemented laws that increased it to bigger employers in those counties and in the food sector industry, basically on the theory that Congress had the theory that there were already benefits in place for larger employers. You had to have this poster up, and all of this expired on December 31, 2020. Now, why did I go through this for you? Because just in December, Congress extended it on an optional basis for you through March of this year. So the first quarter of 2021, you as an employer still have the option to use the FFCRA leave for the same reasons that you had. And why would you want to do that? Well, you might want to do that for just being a nice employer, of course, but you're really going to want to take advantage of that potentially because of the new Cal Osha regulations that were put into place. We're going to go through those right now. So at the end of November, on November 30th, Cal Osha kind of surprised us all. They weren't talking to anybody when they rolled these out. And these are some very comprehensive and frankly pretty onerous requirements that Cal Osha have rolled out. They're going to stay in place up until October 2 of 2021. at which point in time they might be extended. We'll have to see what happens. I'm getting out of your view. But these you really got to pay attention to. We're going to go through them. I'm going to give you an overview right now, but bottom line is you're going to have to put together your own prevention plan that goes along with this, those of you who haven't done it. Now, a lot of what these regulations say, frankly, mirror the county orders and the state orders that you, or the state guidelines, the checklists, the protocols that you've already hopefully filled out, tacked up near the front entrance of your workplace. Those of you that haven't, you should. They're available online. So some of this is not going to be news to you, but basically these apply to pretty much every employer except for people in the healthcare industry. It's a little bit different, but you've got to have a written COVID-19 prevention program, right? And that program includes a lot of specific requirements, right? First of all, you've got to have a communication system to inform your employees of your prevention procedures. So that's going to mean that you're going to be doing training on it. You're going to have posters up, and you're going to have the checklists and protocols in place. So employee training there's a lot of specific requirements to that, but it basically involves going through all the things that you already are doing: social distancing, taking people's temperatures and screening them when they show up to your workplace, making sure that any lines or areas where people might congregate are spread out, checking your ventilation system, making sure that people can be outdoor if possible, that windows are open, where that's going to help with airflow, that you have a system for investigating any COVID outbreak or even a single COVID incident. You are supposed to check into where it occurred, the date that it took place, who was impacted, and what days of work they were showing up, because we'll see in a minute, or I will tell you right now, the infection period for COVID is 2 days before you're diagnosed or develop symptoms, and for 10 days thereafter. And therefore, anybody you work or come into contact with during that period of time is potentially exposed. The actual definition, according to the county health department right now, is if you spend 15 minutes or more within a 24-hour period with a person who has tested positive, you have been exposed. And those people are now required to isolate and go home. So that's going to be part of your plan. And of course, if you share drinks or utensils or get sneezed on, that's also exposure. But you've got to have face mask requirements. You're going to record any incident of a COVID exposure, the same as you do any workplace accident, essentially. Any person that's been exposed, again, using that definition of 15 minutes within a 24-hour period, with or without masks on, that person is going to be sent home and required to isolate for a period of 10 days. Once you have a single workplace exposure, you are required to test anybody that has been exposed, potentially at your expense as an employer. Okay. And you're going to have to give notice to anybody that might have been exposed. Now, these notice requirements that are in this particular set of regulations are really dwarfed by new legislation that became effective on January 1st. So I'm going to cover that for you in a little bit, but that's AB 685. So it's about, I don't know, 5 or 6 slides down the road here. You're going to have, in your plan is going to tell what the return to work requirements are. It's basically that people can't come back until they have been out for 10 days. If they have no symptoms, they can come back after 10 days. If they have had symptoms, they can come back after 10 days and their fever has broke and they have had improving symptoms for 24 hours. Essentially, that's going to be all in your written COVID-19 prevention program, which, just quick polling question, can you have, does your existing OSHA illness and injury prevention program, does that meet these regulation requirements? Quick question. What do you think? Will it? do we got?
7 responses.
Okay. It looks like most people are right on top of this. So yeah, you already have, if you're doing your job right, you already have this OSHA illness and injury prevention program. Every business is supposed to have it. This is something that's been in place for many years. Really doesn't ever bother you unless you have a workplace accident. And then if you don't have one, you can get fined and it can make things worse for you. In terms of COVID, your existing plan isn't going to work. So you're going to have like basically a document that you can attach to the existing plan. It's supposed to be available for your employees to see if they want to see it, but it's more or less to guide you in these situations and to make sure that you have this record, that you've taken the steps that you need to take in order to prevent COVID from happening and to respond to it when it does. So no, your existing plan is not going to work. But here's the big news that came with this. This isn't that new. All of this sort of repeats what you already had in your checklists and your protocols from the county and from the state of California. Here, though, now you are required as an employer for the first time, outside of that FFCRA that we had from the federal government that basically expired at the end of the year, you are required as an employer to continue the earnings, seniority, the benefits, whatever, for workers excluded from your workplace due to a COVID-19 exposure. So that's people that come down with COVID from work. They're going to work. They're not staying at home. They're not working at home. But you require them to go to work, and at work they were exposed. They came down. They're ill, or they are required to quarantine because they were exposed at work. They were within 15 feet of somebody, 6 feet of somebody for 15 minutes or more, and now they're going to be required to stay home. And you're going to have to pay them to stay home. It's not that $511 per day. It's whatever their regular rate of pay is for their regular work schedule. But that's why I said you may want to take advantage of that FFCRA option through the end of March, because obviously then you get the tax credit for it. Now, I will tell you that there is a bill that's been proposed at the California state legislature up in Sacramento that will allow you to get a tax credit for these expenses. And frankly, for expenses that you might incur in implementing the program itself, such as testing after a workplace exposure. But that bill is a long way off of getting signed. It's AB 62, I think, and we'll just have to see if it goes through. If it does get signed, it won't get signed until the end of the year. So I would take advantage of the FFCRA option, at least through March. You can consider public benefits. This is literally the wording of the regulations, that you can consider public benefits, employer sick leave, FFCRA, if it's not covered by workers' compensation. And I will tell you in a minute when it would be covered by workers' compensation. In meeting these requirements, you can consider these options in meeting your earnings requirements, but it doesn't exactly say how that's going to work out. So does that mean that maybe you've got state disability as an option to help you pay for these benefits? Maybe, but it's a brief 2-week period. I don't think you can wait around and wait and see what happens. Okay, more about the regulations. So little bit different tweaks kick in if that one workplace case turns into 3 or more. When you get 3 or more cases in a 14-day period, that's defined as an outbreak. And an outbreak is a bad thing. So what does that mean? When you get an outbreak, you've got to notify the health department. The county health department has to be told immediately. And you've got to start testing people. Again, you were already testing people that might have been exposed when there's a single case. But now you're going to have to test everybody that was at that workplace within, or that once each week during a 14-day period following the case, these 3 cases, until you're clear. You're going to keep doing it once a week. You've got to pay for that testing. They can go out and do it. It doesn't have to be at the workplace, but you're going to have to pay for that option once a week until you're clear for 14 days. You got to investigate the outbreak. You got to investigate any case that's positive. What does that mean? Investigate, it's a pretty grand word, but it means you're looking into how it happened, where it happened, and how you might have made things better. Reviewing your policies, your controls. Are you doing enough? Are you screening people? Are people sneaking in through the back door and not being screened? That's the kind of thing you want to stop. You got to take corrective action. Cannot require a negative test to return to work, but you certainly can require testing at work or ask people to test. You've got the option to ask them. If you have a major outbreak is defined as 20 or more cases in 30 days. If you have a major outbreak, then these rules kick into double time. You're testing twice a week, and you're going to keep doing that until you are clear for a 14-day period. Okay, if you don't follow these instructions, there are lots of fines and penalties that can result, and they are all classified, or can be classified, I should say, as willful and serious. Willful and serious is important to you as employers to know about because it's not covered by most insurance. So you'd be on your own and dealing with those. And these stay in place until October 2nd, 2021, again, unless extended. Okay, workers' compensation. I told you I would tell you about the workers' compensation rules. So basically, what the state legislature did is they enacted a statute that was designed to continue what Governor Newsom started in the middle of last year when he put out Executive Order N6220 and expand upon it further. First part of the statute says that a commission will study the impact of COVID-19 claims on the workers' compensation system, which I think is kind of funny because they're going to study how much it costs after it costs us. A lot of times I like to know what things are going to cost on the front end, but that's okay. And what that order said, and this is, again, probably old news to you, but it's in the new statute, is that there's a presumption that you have COVID-19 that will be covered by workers' compensation if you were diagnosed within 14 days of working and you worked at a place of employment rather than your home. So you were sent somewhere by your employer. And that case came down between March 19 of 2020 and July 5th of 2020. Those people pretty much automatically get workers' compensation coverage. But the statute doesn't stop there. They are allowed or required to use their paid sick leave first before benefits kick in. They can continue, they can be qualified as having a temporary disability, provided they keep recertifying themselves as such, which gives them basically extended benefits. And there was a rebuttable presumption that they have the coverage. How do you rebut that presumption? I'll talk about that in a minute. But basically what you need to know, and this isn't true of just these people, it's true of what I'll tell you in a minute, that there is a smaller window to reject a claim if you want to rebut the presumption of workers' compensation coverage, okay? So for other people, because I'm going to assume that anybody that had it back through July has already made a workers' compensation claim, although that may not be true for you. We have extended workers' compensation coverage past July for a lot of folks. First of all, anybody that's a first responder or a healthcare worker, so police officers, first responders, all those folks, firemen, are covered. And there is also a rebuttable presumption of benefits for anybody that tests positive within 14 days of a workplace outbreak. Now, you'll remember the Cal Osha regulations that we went over not long ago, right? 3 or more people diagnosed within 14 days is an outbreak, right? This outbreak definition is different. Why is it different? Because branches of our government don't talk to each other. We haven't figured out how to do that yet. So if there was a way for them to communicate, you know, like send electronic messages or something. I mean, I know I'm talking futuristic stuff here, but if we had that, maybe we'd have the same definitions, but we don't. So for workers' compensation, outbreak is defined as if you have 100 or more employees, you got to have at least 4 employees become diagnosed with COVID-19 in a 14-day period. If you've got more than 100 employees, did I do that wrong? Fewer than 100 is 4 employees. More than 100 is 4% of the workforce. Okay? 4%, you've got yourself an outbreak. When you have an outbreak, you've got a rebuttable presumption of workers' compensation coverage for the people that become COVID positive. How do you rebut the presumption? All right, and this is true for all of the workers' comp presumptions. How you rebut it is you have to show that you had measures in place to stop COVID-19 from happening. So how are you going to do that? You're going to have to show that you had the protocols up, that you had the checklist up, and that you have a written COVID-19 prevention program. That you have a plan, actually, is what it's called. Written COVID-19 prevention plan. And you have to show that the employee took a non-occupational risk of infection. That's kind of verbose, but what they mean is the employee did something other than work. They went to the store. They went shopping. They went to a family gathering. They went to a big New Year's Eve bash. I don't know what it is, but all of those would be a risk of exposure somewhere else. All right? Okay. And this all became effective immediately upon September 17th, 2020. I'm kind of going through the stuff that was COVID related and was immediately effective upon passing first. And that's it. It expires on January 1, 2023. So quick polling question about this. Do employers have to report to OSHA any hospitalization or death of a worker due to COVID-19 work exposure? True or false? That's good. That's terrific. So most of you are saying true. That's correct. So I mentioned earlier that you have to report an outbreak when you have 3 or more, and that is true. But what I didn't mention, and which apparently a lot of you already know, is the old OSHA rules didn't go away. And the old OSHA rules basically said that when you have a hospitalization in terms of a workplace injury or a death in terms of a workplace injury, those have to be reported right away. And it hasn't changed for a COVID-related workplace exposure. So you would still have to report if somebody is hospitalized or if somebody dies after contracting it through work. Even when you're not really sure if it was work-related, you should still report that. Okay, so moving on. AB 1867 was passed to basically try to help the food workers out there, right? So we all know that the restaurants are about to open back up. This statute really isn't just limited to restaurants, it's anybody that works in the food sector, but it allows people to wash their hands. As originally written, they could wash their hands continually. We decided that was a little bit too much, so now they get to wash their hands every 30 minutes or additionally as they may need to, and we're gonna let them do that, and that's basically a paid break. It's on the clock. It also provides, this statute was one of the statutes that I talked about earlier that extended those FFCRA benefits to larger employers in the food sector. Those kind of all expired at the end of December 31, 2020, because Congress didn't extend the FFCRA. Again, it's extended on an optional basis. It's totally up to the employer to decide through the end of March. It also created a pilot program for the Department of Fair Employment and Housing for mediating disputes over family leave for smaller employers with 5 to 19 employees. And that's going to stay in place through 2024. Do I think it's very useful? Marginally, but I'm telling you about it so you know about it. It's part of the statute. And this became effective on September 9, 2020. Some more urgency legislation that was passed, mostly relating to COVID. I will cover this very quickly. Basically, those PPP loans, to the extent they're going to be forgiven by the federal government, they will also be forgiven for state tax liability. So that's good news. In addition, we are allowing, you may not have heard this, but this was already on the books, in terms of allowing people to borrow from their retirement programs if they were laid off, if they suffered as a result of COVID. And we are now allowing that figure in terms of the borrowing ceiling to be raised from $50,000 to $100,000 with an extended repayment program. In addition, we're allowing small business employers to obtain tax credits for hiring employees of up to $100,000. Talk about that with your accountant, because tax stuff is something I just don't like. Okay, moving on. AB 685. So this is the notice statute that I told you about that kind of is more specific and frankly a little more strict than the Cal Osha Regulations. So this is the one that I would want you to worry about in terms of written notice in the event of any COVID-related exposure at work. So any positive test at work or outbreak at work, and I'll go through it right now. Became effective on January 1 of 2021, excuse me. And it requires you as the employer to give written notice, right, within 1 day of becoming aware of a workplace exposure. So a COVID test at work, somebody has been positive and they've come into work. You've got to tell not just the employees that might have been exposed, which was what the Cal Reg said. You've got to tell everybody that was at that workplace, including independent contractors and other employers that work out of the same location, same offices, same building, period. Okay? And what do you have to tell them? You also have to tell the union representatives if you have those. You've got to tell them, and this extends to anybody that might have been there during the infectious period. I think I told you earlier, the infectious period starts 2 days before somebody has symptoms or before they have a positive test, and continues for a whole 10 days thereafter. So positive test, 10 more days, symptoms, 10 more days. So anybody that was at work during that period of time, all of the people they came into, or they were at the same workplace, independent contractors, employees, whoever, would have to be notified, okay? And the written notice must include information regarding COVID-19 benefits. Obviously, that's more for your employees, but independent contractors can apply to the state of California. And under federal law, so that's FFCRA to the extent it's still available, optional basis. Workers' compensation rights, what those are, has to tell them any legally mandated or employer-provided sick leave options. So whatever city or in the state of California, you've got state-paid sick leave, and that's enhanced in some cities, Los Angeles and Santa Monica among them. You've got to tell them as well that they will not be discriminated against for having COVID, and that they will not be retaliated against. And if you provide as an employer greater benefits than the state or city in which you're in terms of paid sick leave, you have to remind the employee of that as well. And you've got to tell them, this is the written notice still, that what you're going to do about it. What are you doing about this COVID-19 outbreak that you've had or positive test case that you've had? You're going to be cleaning. You're going to be implementing your safety plan. You're going to be testing at the workplace. Whatever it is that's different, you're going to have investigated it, because you have to do that under the new Cal Osha regulations. You're going to be telling them what you're doing. It's not 6 pages long. It's still like a paragraph or so, but you do have to do it. That's the notice requirements. Additional notice requirements got to be in English. And if there's another language that's understood by the majority of your workers, it has to be in that language as well. And you've got to keep the evidence that you complied with this statute for 3 years. So keep a copy of the written notice. And by the way, when you put that notice out, it doesn't name the person that was tested positive, right? So no personal identifying information is to be transmitted to your workers and independent contractors, both under the Cal Osha regulations and under this AB 685 statute. Okay, the notice requirements expire on January 1 of 2023. So you're going to be doing this for a while. The new theory is that this is going to be just a regular flu season type of thing that's going to be going on for us for a while, that we're going to have to get annual flu shots for COVID-19 for the foreseeable future. So for the next couple of years, you're still worried about this, okay? If you've got a COVID-19 outbreak, which we heard in Cal Osha regulations was 3, for workers' compensation purposes, it's 4 if you're under 100 employees. For this statute, they tied it into the California Department of Public Health, which, lucky for you, is the same right now as the Cal Osha regulations. So that's 3 cases within 14 days. Then you also got to provide information to the Public Health Department. And what you're going to provide is the names, the number of people, occupations, the work site of all the, where it took place. You're going to tell the Department of Health how many people had it, who they are, and what they did for you in terms of their jobs and where the actual test cases occurred, positive tests occurred. And that's it. So you got to tell them, and that includes people obviously that have died or are hospitalized. Okay. You've also got to tell the Public Health Department of your business address, I already said that, and your North American Classification System code for the work site where the qualifying individuals work. And basically it's the same information that you larger employers are already familiar with. It's the information that's required in a Cal Osha Form 300 incident report. Unfortunately, it's going to apply even if you have fewer than 100 employees, which is when that kicks in. Sorry, I'm mixing concepts up here, but basically when you have a workplace accident, you have to use that report, and you'll have to use it for this COVID outbreak. All right. Subsequent cases must also, once you have an outbreak, you have to report every future positive test case after that. And this does not apply to healthcare facilities. All right. The California Department of Health is going to make the information that you provide to them available on their website. It's not going to include any personal information, but there is a public shaming aspect to some of these statutes. So it's going to be available on the website, and nothing you can do about that. Just know that it's going to happen, but you have to comply with the statute or you will be fined. Cal Osha has increased enforcement abilities under this new statute, and they're pretty harsh. Basically, if as a result of your outbreak, they determined that you weren't in compliance, that you didn't have a prevention plan, that you hadn't been screening people, that you hadn't done what you were supposed to do in terms of making people wear masks or keeping people socially distant, you have the possibility that you will be designated as an imminent hazard type of facility, in which case they have the ability to close your business. And they can do so much more quickly than they could under the old OSHA regulations. You know, basically you're looking at immediate shutdown rather than a 15-day sort of notice requirement. So you want to stay on top of this stuff. Okay, moving on. We're now going to get out of COVID for a little bit, which I think is probably going to be a breath of fresh air for all of us. Here, I'll shut that off. Okay, so AB 1512 modified rest break requirements for security guards. Bear with me. This has meaning for your businesses, okay? Basically, this all related to a case called Augustus. The Augustus case went all the way up to the Supreme Court. It had to do with the fact that security guards were required in most businesses to keep their walkie-talkies or their cell phones, whatever they had, with them while they were on duty, sorry, during their rest breaks. Not on duty, they were off duty, but they were supposed to just keep nearby. They were supposed to have their walkie-talkie or whatever handy in case something happened. Kind of common sense. And as a result, there was a class action that basically held that, no, you can't do that, all right? So what this did, and it was kind of a well-intended statute originally, but something took a left turn in the process. And as a result, you basically have this statute that says, the first part, very common sense, that a security guard can be required to remain on the premises and be called upon to carry and have a monitoring device with them, their walkie-talkie, whatever. And if they get interrupted, they can just start their rest break over, right? We're not talking about meal breaks where they're off the clock. We're talking about rest breaks. Makes sense. And, you know, that there is a penalty if they didn't get their break at all. They get a penalty just like everybody else does. If they don't get their rest break, it's 1 hour of additional pay. This is a law that's been on the books forever. These guys also get, or people, I should say, also get a penalty of an hour pay if they don't get their rest break within more or less every 4 hour period, okay? But here's where the train kind of leaves the tracks. These exceptions only apply where the security guards are working under a collective bargaining agreement, meaning they're part of a union. So this is kind of our legislature's backdoor way of forcing unionization of security guards, because most security guards are not, in fact, unionized in the state of California. The statute became effective immediately, but it doesn't apply to any lawsuits that were already filed or that will be filed after the statute became effective all the way through January 1 of 2021. And the whole thing is going to expire on January 1 of 2027, because after that, we won't need security guards, apparently, right? So why am I telling you all this? I'm telling you all this because this case is still out there, except for those people that are going to be unionized under this statute for this little bit of time. And that case wasn't just about security guards. It was about rest breaks in general, right? So, for example, polling question. Workers can be told not to leave the premises during a rest break. True or false? So we've almost evenly divided here, okay? It's false. You cannot have people stay, you can't control them in any way, shape, or form during their rest break. They've got to be able to do whatever they want to do. Now that practically means it's only a 10-minute break. It means they could walk 5 minutes away, turn around and walk back, but they have to be allowed to do that. You can't have your receptionist stay at the desk because the phone might ring during a rest break. That's not how it works. And this case is still valid law for that, right? And even though we kind of took a step to look at the practicalities of some professions, in this case, just security guards, doesn't impact any of you folks. So be aware, rest breaks, don't control them in any way, shape, or form. All right, AB2143 Modified. So this was a horrible law that was initially passed last year. AB 749 basically prohibited the use of no rehire clauses in a settlement agreement. So I don't know if any of you have ever had the misfortune of having been involved in a lawsuit with an employee or a former employee, but a lot of times when that lawsuit's over, if you were lucky enough to settle it, you pretty much want to part ways. You don't really want to be doing business with each other anymore, right? And so you have these clauses that are no rehire clauses, basically saying that, hey, you agree that you're not eligible to be rehired by our business and you won't apply for a job. Sounds like a great idea until this law came along and said that's not going to be allowed anymore. In the state of California, a no rehire clause in a settlement agreement is illegal. It's unenforceable. Now, there were some exceptions built into the original law, which have now been expanded upon with this new law. The original law said that you could have a no rehire clause if the employer had made a good faith determination that the employee who you were in this lawsuit with or dispute with had engaged in sexual harassment or sexual assault. So pretty limited. This now expands that exception to include any criminal conduct if you had determined that that employee that you were in the dispute with had engaged in any criminal conduct. However, there's a couple of caveats to that. One is good for you. It says that the original claim brought by the employee must have been in good faith. To me, I don't think that's very useful because it's not very often that you're going to get somebody to agree that they filed their claim in bad faith or that you can prove that it was in bad faith. But the other requirement is that you have to have determined that they engaged in sexual harassment or sexual assault or criminal conduct before that employee ever made a claim against you. So you can't take advantage of that no rehire exception unless you can prove that you had already made that determination. So pretty narrow set of circumstances where you're going to be able to have a no rehire clause, which effectively means, and this is why this statute doesn't make sense to me, that you can have a knockdown, drag out dispute with somebody. You can finally reach some kind of an agreement. And then afterwards, they can come apply to work at your place of business again. And you can say no, because you know that you don't want to be in another fight with them. And then that would be retaliation and they could file another lawsuit. So your legislature hard at work. Okay, next statute, AB2257. All right, so this is kind of the big bear that was part of the legislative agenda. You know, I thought 2020 was going to be an easy year. I really did. I thought, for me at least, it was going to be, because, you know, the legislature went home for 2 months. How could they pass laws? Like, what could really happen? You know, it had to be less, right? And turns out they still passed hundreds of laws. Governor Newsom still signed hundreds of laws. And this was the bull in the china shop of the law. So you're all familiar with, I hope, AB5, right? AB5, you all remember AB5? Show of hands. Okay. So AB5 was the law that essentially codified, turned into law, the case holding in the California Supreme Court case of Dynamex, right? Dynamex was this kind of, how do I describe Dynamex? It was a case that really where the California Supreme Court was looking ahead at businesses like Uber and Lyft, and they were trying to basically simplify their lives and the lives of the courts in California and get rid of what they thought was becoming a cumbersome independent contractor test called Borrello, which was a multi-factor test that kind of focused on right of controlling the worker. If you control somebody, they must be an employee. If you don't control them, they must be an independent contractor. It was like an 11-factor test where you looked at things like, you know, did they get paid by the hour or by the job? Did they work for other people? Did they have an established business? Things like that, okay? And Dynamex said, oh man, that's just too complicated. Let's switch over to a mandatory 3-part test that's really designed for our modern world, the ABC test. And it created havoc because the ABC test, and I'll go through it in a second, put a lot of people out of business because it doesn't apply to every situation, right? It just, you know, for example, well, let's take a look at it. The ABC test, A, and you had to get all 3 factors right. A, you had to be free from control or direction of the hiring entity. Well, that would be true in any independent contractor relationship, and it was true under the Borrello test, and, you know, we're pretty used to that, and that's okay. But B, the work that is performed has to be outside of the course of the hiring entity's usual business. So just by way of example, Dynamex comes out and the entire medical profession just starts screaming. Because when you go into a hospital, you expect to see what? Like a doctor, maybe, right? Well, guess what? None of those doctors are employees of the hospital for the most part. And what are hospitals in the business of doing? Providing health care. So therefore, no doctor could be an independent contractor. So just entire industries started like thrown into turmoil. Part C was, and the person has to have an independently established trade or business that's doing the same thing for you that they're doing for other people, right? Got to be the same stuff. So you can't basically have a business that could do work for other people. It already has to be in business doing work for other people. That was the ABC test established by Dynamex. To me, it always raised the question of like, how does an independent contractor get their first job? Because when you get your first job, you have to be already have been doing it for other people. So a little bit of circuitous reasoning there on the part of our Supreme Court judges and the legislature, because the legislature took that ABC test and they passed AB5 last year. Dynamex created utter turmoil, and AB5 was the legislature's attempt to come in and kind of sort things out and figure out like maybe sometimes it doesn't apply. When is it, when is it not going to apply? Are there exceptions? Whatever. And they took a methodology which was, well, pretty difficult because you had this earlier Borello test. It was kind of a one-size-fits-all kind of test, but it wasn't, the factors could be loosely applied and you didn't have to have every factor right. This, of course, was the opposite, a rigid three-factor test. You got to have all three factors right. So now the legislature takes this and they say, okay, well, how are we going to like make this work for other types of professions like doctors? And what they did was instead of trying to come up with a new kind of overview system to maybe, a framework, a policy analysis type of situation, what they did was try to create a statute where they literally thought of every job and what exceptions might exist for every job, right? An incredibly difficult, and I would argue, impossible task. So AB5 comes out and it's a total mess. And it literally, it's like 18 pages, single space, and lots of businesses are still not able to do business. You couldn't, for example, have a subcontractor. It's not possible to have a subcontractor under AB5. The music industry was thrown on its head. You couldn't have freelance writers. So magazines couldn't really hire freelance writers after a certain number of times. It was limited to 35 times. Why 35? Who knows? It was the result of a lot of lobbying and a lot of backroom, smoky room kind of stuff, and wasn't really good enough. So now we have AB2257, which was the legislature's attempt to rewrite AB5. And I guarantee we're not done. We're going to get more next year. But here's AB2257. It keeps the ABC test. This is where you start. There is a presumption that every person you work with is an employee until you, the hiring party, proves otherwise, right? So it's not up to the independent contractor, it's up to you. So got to get all three of these factors right. If you can't get these factors right, you might be able to take advantage of a loophole. And what are those loopholes? Sorry, I'm all over the map here. Here we go. Well, the first one is the business-to-business exception. They actually did improve this. This is better than it used to be. How does it read? Number one, the business service provider, the person that you hired has to be free from control. So that's still the same as like Borello. It's part A of the ABC test. That's fine, right? Free from control, both in the contract and in the actual performance of the work. Okay? And by the way, you're going to find contract kind of all through this, written contract. Those days of doing business on a handshake, they're over. You got to start having written contracts with anybody that you're going to be doing business with. All right. Number two, that they're providing services directly to you and not your customers. Okay? Well, the old version, AB5, stopped right here, but now we've allowed the possibility of a subcontracting relationship, and the person that you've hired can provide the services to your customers, provided they do so in their name. So not in your business's name, but in their name. And provided they also are doing the same thing for other businesses. Okay. The contract's got to be in writing. I've told you that. It's got to specify the payment amount, rate of pay, and the due date for payments. Okay. The service provider has to have, it just drives me nuts. It's all through this statute. Okay. So now, for the first time, we are going to make you, the person that hired the independent contractor, we're going to make you determine that the independent contractor has any required business license or tax registration. Okay, why? Because we want to make sure the state's getting their dues. They want to make sure they're getting paid. And we're going to shift that burden to you, the people that are hiring independent contractors. Absolutely drives me nuts, but you've got to do it. You can't just have a line item in the contract that says you confirm that you have the required business license. That's not going to cut it, because it's your burden of proof to show that they have it. All right, they've got to maintain a business location that's separate from yours. It can be their house, can be their home. That's fine. They've got to be customarily engaged in that business that you're hiring them for, and doing the same work as what you've hired them to do for other people. They've got to be able to contract with other businesses to provide the same services. So a lot of you have contracts where you've got some kind of exclusivity kind of provision. It says, while you're working with me, you're not going to do what you're doing for me for other businesses, right? Or you'll devote your the majority of your time to me. You'll put me first. Those kinds of things. Get rid of them. You can't have any of those clauses anymore in your independent contractor agreements. Okay? No restrictions. The provider has to advertise. They've got to hold themselves out as being available for business. So what does that mean? It means they're on LinkedIn. It means they've got a web page or a website or a Facebook profile or something where they're saying, hey, I'm open for business. And you're the one that's got to make sure that they have that. Okay, they've got to provide their own tools, vehicles, equipment. They've got to be able to negotiate their own rates. They've got to have the ability to have set their own hours and work location. That's within the framework of the job itself that needs to be done. Obviously, if they're house painters, they've got to paint during the day and they got to be at your house. They've got to, and this doesn't apply to contractors, construction people that are licensed by the state contractor licensing board don't have to meet these requirements. And this was something else that changed from AB5. We're going to allow you to have this business-to-business relationship with sole proprietors. So as originally drafted, they had to be corporate entities. They had to have a limited liability company or a corporation. Now we're going to allow sole proprietors to do this, which means basically they've got to have a business name. I would suggest they've got to register a DBA, something like that, so that you can prove that this person was actually in business. Because if you can't, you don't get to take advantage of this, and you get sent back to the ABC test, which you don't want. And remember, taking advantage of this only means you get to go to Borrello, and then you have to worry about the Borrello factors. But again, those are a lot easier. It's all just random control stuff. Okay. Bunch more to this statute. A bunch more exceptions apply. One of them is referral agencies. I don't know if referral agency is at all interesting to you, but I'll go through it just quickly. Basically, you can have a referral agency and not be stuck employing all the people that you refer out for business, provided you're able to show that the people that you're working with, the people that you're referring out, are sole proprietors or business entities. again, because if they're not, then you got to go back. If they're just individuals that don't have a business, then you got to go back to ABC. And you can show that they're free from control and direction by you, that the person has all the business licenses and tax registrations that they're required to have wherever they work, so whatever jurisdiction they're in or county. And you got to keep those documents for 3 years. That they have any required contractor license or any license or permit certification for their particular type of business that they're doing, which again, you got to keep a copy of for 3 years, right? That they're delivering the work that you're referring them out to do, they're doing it under their own name. They're not doing it under your name, right? They've got to have their own tools. They've got to have their own supplies. They got a truck. They got whatever they need, right? That they're in this business and they're doing this business for other people. So they're established as a business. This is not like a lark that they just decided to do with you for the first time. That they've got clientele and there are no restrictions from you with respect to their clientele. They can do work for other people. They can go out and post on multiple websites for work or referral agencies for work. They've got the ability to set their own hours. They can negotiate directly for rates of pay with the people they're working with, which, by the way, is going to make it harder for the referral service to get paid because the service provider is the one that's getting paid by the client. So they're going to get paid and you can't take a piece of their action. So I don't know how referral agencies are going to work now. They're going to have to get paid up front for the referral by the provider, I guess. And they can't be penalized in any way, shape, or form for turning down a deal, unless, of course, they didn't do the work or they failed to perform. Okay, referral agency. So as originally written in AB5, it was a limited, finite number of potential referral services. The legislature's starting to adapt to this. They're starting to think in broader policy kind of terms. So basically, it's not limited to this list, but this is an example of the services that will work. So basically, graphic design, web design, photography, tutoring, consulting, youth sports coaching, caddying, because we need caddies, wedding or event planning, minor home repair, errands, furniture assembly, animal services, pool cleaning, yard work, all that stuff works. The only thing that doesn't work is they've carved out a limited number of businesses that they determine to be high risk. So OSHA or Department of Industrial Relations, high hazard types of businesses that deal with toxic chemicals, things like that. And businesses that are frankly more likely to be subject to unionization, transportation, couriers, delivery services, agricultural labor, all of this in-home care, construction services, none of that can be part of a referral agency situation. That would all be subject to ABC test. Okay, professional services is something you should care more about. That has been expanded, but not a lot. So there is an exclusive list of the people that can qualify for professional services, but before you get the privilege of potentially applying the Borello test as a professional service provider, you, the hiring entity of the professional service provider, has to be able to show these factors. You've got to prove it. Again, the burden of proof is always on you under this statute. Number one, that the professional service maintains a business location that's separate from yours. It can be their residence. Okay, even though they may do all the work at your office, they still have their own office. After March 4th of this year, the service provider has to have any required license or tax registration in addition to any required professional license or permit. And again, that's your burden to show that they have it. They've got to be able to set their own rates and negotiate their own rates. They've got to be able to set their own hours of work outside of any deadline or completion date. They've got to be engaged in the same type of work they're doing for you, for others, or at least hold themselves out as being able to do work for others. So again, they've got maybe that LinkedIn page or Facebook page or website where they're open for business. And that the work itself is professional, intelligent, kind of demanding work and requires them to be regularly engaged in the application of discretion and judgment, independent judgment. And if you can get all of those factors and you're one of these companies, then you get to apply the Borello test. So what are these companies or categories? Marketing, original and creative marketing work. So I guess potentially influencers, advertising execs, things like that. Don Draper would be able to qualify. That they're human resources folks that are predominantly doing intellectual work. So HR consult types that are coming into your business to help you out. Travel agents, graphic designers, grant writers, fine artists, enrolled agents licensed by the United States Department of Treasury, the IRS. Never quite knew what those people did, but they're out there. Payment processing agents that work through an independent sales organization. And this, you're going to see a few of these big paragraphs. Basically, this tried to deal with some of the things that the legislature limited too much. I was going to say overly limited in AB5 by, like, for example, restricting freelance writers to 35 submissions to a given employer within a year. We've gotten rid of all the 35s, but we have a lot of restrictions for these folks. And basically, they get duplicated. So I'll go through them this one time and then more quickly. But so for photographers, photojournalists, videographers, photo editors, they can be professional if they work under contract that specifies the rate of pay and provides a pay deadline. And they are not replacing an employee who is doing the same volume of work, right? And they're not performing the work primarily at your location, right? And they're not restricted from working for others, period. They can be a professional service provider. All that's fine. It doesn't apply for this particular category to people in the motion picture or television industry, basically because a lot of that work is unionized, so we're going to carve out that. But same thing here. So freelance writers, editors, translators, copy editors, newspaper cartoonists, all those people that were put out of work by AB5 or forced to relocate out of California, we're now saying they can be an independent contractor as long as they're working under a written contract that specifies the rate of pay, as long as they've got a pay deadline, as long as they're not replacing some person with the same volume of work that works for the employer, and provided they're not working primarily at your place of employment and they're not restricted from working for other people. Okay, same thing here. Content contributors, advisors, producers, narrators, cartographers. Thank God. We're at the point where this is what happens when you try to regulate every single profession in one statute. Okay, we have a law now for cartographers. Later on, you're going to hear about how we've also regulated mimes and puppeteers. So that's the direction we're headed in, folks. But these people, if they're working on a publication, they can also be professional service providers subject to Borello and therefore independent contractors, as long as there's a written contract where there's a specified rate of pay. In this particular instance, it's got to also talk about who gets to own the intellectual property that's being created. It's got a pay deadline. They're not going to be replacing some employee, and they are not performing the work primarily at the hiring entity's location, and they're not restricted from working for other people. Okay, which can be difficult for some of these people because you're going to hire a producer. You don't want to be working on the same project at a competitor, but you're not going to be able to restrict them if they're going to be an independent contractor. Okay, all your beauty care industry professionals, estheticians, electrologists, barbers, cosmetologists, and manicurists, although their exception expires at the end of 2022, provided they set their own rates of pay and they're paid directly by the clients. They set their own hours of work. They have sole discretion to decide which clients to see and how many. It's going to make it really hard for a lot of beauty salons to operate the way they've been operating, because basically the barber, if you will, has to decide who they're going to see. They've got to book their own business. They've got to schedule their own appointments. They've got to maintain their own business license while they're performing there. They've got to issue a 1099 to the owner if they're renting space. But, you know, what's the point of having a salon anymore? Because they can't book the appointment for you unless they've checked with you. All right. Specialized performers hired by a performing arts company can be a professional service provider. If they're teaching a master class for no more than 1 week, appraisers, professional foresters, real estate licensees, a repossession agency that's free from control and direction, which is a shame because I always told people how to do the repossessing. Now I can't do that. All right, ABC test will also, so that was professional services. It will also apply to a relationship between two individuals where each one is a business or sole proprietor, and they're getting together to do a job, to perform some sort of work at a single event kind of situation, which is actually defined as one event, or it can be a once a week kind of thing, but no more than once a week, because twice a week is bad. Provided that the parties can show that neither one is subject to the control or direction by the other, both under the written contract, again in writing, and in fact, that each one has the ability to negotiate their own rate of pay, that the written contract provides for the amount that they're going to be paid, as well as the amount that each one of them will receive from the event and the rates of pay for each, that each individual has their own business location, which again can be their house, that they've got their own tools, their own equipment, that they've got the required business license for tax registration, so you get the pleasure of checking each other's license and registration, that they're customarily engaged in doing the same or similar work for others, and they're available to do that work for others, and that they can contract with other business to do that work, okay? And I think I already told you that it's a single event or no more than once a week. And again, we've carved out things that we think are high risk, so this single event or single engagement exception is not going to apply to people in high risk industries, high hazard industries, as well as certain industries that are frankly subject to other regulations like trucking, transportation, delivery, janitorial services, retail, logging, in-home care, and construction. Okay. We also had to try to bail out some of the industries that got hurt by AB5. So now we have an exception for recording artists, songwriters, because the music industry was just killed by AB5 because all those people are independent contractors. So songwriters, lyricists, composers, proofers, managers, record producers, directors, musical engineers, musicians engaged in the creation of sound recordings, vocalists. Now I put asterisks on here, and those asterisks actually mean something. And what it means is for those people, basically anybody involved in music can be an independent contractor, but for people that are performing the music, you can't be an independent contractor unless you get a royalty slice from the composition. So if you're not going to get royalties, then you have to be an employee. All right. Single engagement live musical performance events it's a whole nother category. I'm not going to go through it, but it has to do with like the size of the venue and the number of tickets sold. But a lot of those can be independent contractor situations, as well as an individual performing artist that's performing material that's their own original work and creative in character. All of those people can also be subject to Borello. And they literally, in this statute, got into the minutia of puppeteers and mimes. And on the subject of mimes, what's our next polling question? The mime you have hired to perform the famous trapped in a glass box routine is an independent contractor. True or false? That's this one. That's where you go like this. Oh my God, I'm in a box. True or false? So most of you said true. So the answer is maybe, but maybe not, because you're telling them what to do, right? They have to be performing their own material that's their own original work and creative and character. So you're saying, come to my party and do the glass box Marcel Marceau routine because, you know, my family and I are just nuts for that stuff. You may have a problem. They may be your employee. Okay. Bunch of occupations got carved out as well. Insurance agents, brokers, physicians, surgeons, dentists, lawyers, architects, landscape architects, engineers, private investigators, accountants, registered security brokers, direct sales people, as long as they're getting paid by the sale rather than by the hour, and there's a written contract that says they're not an employee. Also can be independent contractors, subject to the Borello test. Additional categories, commercial fishermen on American vessels, but only American vessels, because other vessels, that's right, un-American. Newspaper carriers, distributors working under a contract, manufactured housing salespeople, competition judges with specialized expertise. That's the level of detail we've gotten to, folks. Construction subcontracts and data aggregators. I thought that was agitators when I first read it. I thought maybe that's the QAnon people. I didn't know. But they can also be independent contractors provided certain conditions are met. Very sort of a right of control kind of stuff that's built into the statute. I won't bore you with that stuff. Proposition 22 took the app-based drivers out of this equation. So now the Uber and Lyft and Postmate folks are guaranteed 120% of minimum wage and some healthcare benefits, and we don't have to worry about this stuff for them. This all became effective on September 4th, and I will tell you that there was a California Supreme Court case that came down on January 14th, Vasquez versus Jam Pro Franchising, that in fact validated what the legislature had already said, which is the ABC test is retroactive. So going back in time. That case was also pretty useful in terms of defining what is your business, part B of the test, what is and what is not part of your business. And they said you need to look at how a business holds itself out. So you look at a business's website, its advertising materials, that kind of thing to determine what it's saying it can do. Okay, this was another big change for this year. Basically, we've expanded the California Family Rights Act, and we've made it available for every employee who works for every employer. Used to be 50 employees or more. Now it's 5. If you have 5 employees or more, you have to offer the California Family Rights Act leave. There was a sort of a halfway statute that kind of was put in place a couple of years ago, called the New Parent Leave Act, that applied to employers with 25 or more employees, or to permit leave for parent bonding purposes, child bonding purposes. That is replaced by this. So now we have California Family Rights Act. If somebody has worked for you for 12 months and has put in at least 1,250 hours of service, they can take an unpaid leave to care for. And this goes beyond the Family Medical Leave Act, folks. So federal law is a little less broad or encompassing than this. So it raises the possibility that someone would be able to take CFRA leave and then take FMLA leave. So just be aware of that. So because here's an example. So in addition to parent, spouse, and domestic partner, we can take a leave now to care for our grandparent, grandchild, or sibling, which is not in the FMLA. Care for a domestic child of a domestic partner. We also can take a leave to care for our adult children. So somebody that's over the age of 18 that has a serious health condition, even if they can take care of themselves, they can provide self-care, we can take a leave to take care of that, an unpaid leave. Covers all kinds of military leaves. I'll leave it to you to read that. Basically kind of in some ways reconciled the statute with the family medical leave, and others it did not. And other differences from the FMLA, it eliminates, the FMLA says if you have 2 employees, they both can't have the FMLA. California Family Rights Act does not say that. It says that both parents can take parental child bonding leave if they both work for you. That's perfectly fine. It eliminates the key employee exception for reinstatement rights. Under the Family Medical Leave Act, you can provide notice to certain people that are key to you that you may not be able to reinstate them. You can't under the California Family Rights Act. So again, you may have the possibility of somebody taking both leaves under both sets of statutes and being gone for 24 weeks unpaid. And you got to continue health benefits during the leave at the level that was in place prior to the leave. That became effective January 1. Something you may not be aware of. This was on the books previously, but now it's been expanded. We've expanded our protections for leave for crime victims. So this requires you to provide leave to an employee who has been the victim of a crime to go and get judicial relief. There's only one part of it. There's a more expanded version in a minute. And that's defined as of any victim of domestic violence, stalking, sexual assault, any crime causing a physical or mental injury or threat of physical injury, and whose immediate, or this should be or, whose immediate family member is deceased as a direct result of a crime. Crime means any crime or public offense which would constitute a misdemeanor or felony if committed in California by a competent adult, and that's regardless of whether or not the police are prosecuting it. Okay, it may not be happening yet, but they still get to take time to attempt to obtain judicial relief. Okay, you've got to keep it confidential, and you have to give them the time to go do that. Now, you can ask for reasonable notice, and they should give you reasonable notice, right? And they can, you can ask for documentation, and the documentation can include a police report, a court order, any documentation from any sort of professional, meaning a medical or healthcare professional, counselor, or any other documentation which would reasonably verify the crime or abuse. And here's the tricky part, including any written statement from the employee or an individual acting on the employee's behalf. So, polling question. You must provide a leave of absence to an employee who simply sends you an email saying that he or she has been the victim of stalking and is seeking help. Yes or no? The answer is yes. That is correct. An email would be sufficient given this definition of documentation. All right. You got to consider reasonable accommodations for the safety of the victim. That's kind of common sense, but now it's codified. Before, I would have told you, that you have to think about protecting your employee. You might want to help them get a restraining order, beef up security, things like that. Now it's in the statute, so you got to think about these things. Now, there's an expanded leave provision of this statute, which applies to employers with 25 or more employees. Basically, what it allows is for the person to take a medical leave of absence of up to 12 weeks, basically FMLA rights, for injuries caused by the crime or abuse. Sorry about that. To obtain services from a domestic violence center or program, rape crisis center, any victim services, basically, to obtain psychological counseling or mental health care services, to participate in any safety planning or take other actions to increase safety on behalf of themselves, including a temporary or permanent relocation. And basically, it's the same documentation standards. So they could send you an email and it would be sufficient to trigger this leave, which again can last as long as 12 weeks. you are required to provide notice of these rights on hire. So it's going to be in your handbook. The DLSE is working, the Division of Labor Standards Enforcement is working on providing a form for you to hand out when you hire somebody. That form's not going to be ready until January 1 of 2022. Why? Because it takes time to write this. And you've got to, again, maintain confidentiality. The person is allowed to use their vacation and paid sick leave for this leave. And that was effective January 1. All right. Expanded leave, paid family leave benefits. This may be old news to you. In July, paid family leave was increased from 6 to 8 weeks. Okay? Not that big of news. What should be news to you is that the government, your legislature, has created a task force to develop a program that extends paid family leave for up to 6 months by the year 2022. Why? Because in the state of California, we are sitting on piles of money and we don't know what to do with it. Okay? So that's in the works. And if you wanted to look it all up, there's where you can find it. Also, we have increased paid family leave to military families. It's just we've extended the coverage for people that are on active duty, and you're married or you're a child of somebody on active duty, they're on a leave, yada yada. I'm not going to spend any time on this. AB 51 in 2019, we passed a law that made it illegal to have a mandatory arbitration agreement with your employees in the state of California. All right. That law was put on hold by this case, Chamber of Commerce in the United States versus Becerra, and the court issued an injunction which prohibited the enforcement of AB 51. And that's where we're still at. So what does that mean? What I'm telling you is it means that right now you can still have a mandatory arbitration agreement. And I suggest that you do, because these cases are expensive and arbitration is a more efficient, frankly, less expensive method for resolving disputes. So have a standalone agreement, state that it's governed by the Federal Arbitration Act, and just be prepared to possibly modify it if this case goes south. McPherson, this lawsuit had to do with unlimited vacation policies. So that's kind of like all the rage these days for professionals. Should we have an unlimited vacation policy? Okay. What this case basically said is you can have it, but you really should take some steps. And it gave advice. It was kind of it was an interesting case because this company had unlimited vacation for their employees, for their exempt employees, people exempt from overtime, but they never put it in writing. They didn't say anything to these people. They just said, be professionals. And so there was no guidance and people weren't clear. And as a result, when somebody left, they tried to get their vacation pay and it turned into this lawsuit. So what the court said is, look, if you're going to have an unlimited vacation policy, make sure that it's in writing. Make sure that it clearly states that the person can take time off and it's not part of their wages. It's just part of, maybe it's part of their flexible work schedule, right? It's not limited in any way. And it should inform them of the consequences of failing to take time off, like getting burned out. And it should clearly set forth that, if they don't take time off, that's not going to be good for you. And we're going to kind of try to make sure that everybody is taking time off that's subject to an unlimited policy. And if you do that, and you're kind of making sure that you don't have like an imbalance where some people are working all the time and some people aren't, then you can have an unlimited vacation policy. So quick polling question on that. Unlimited vacation policies are an option for all employees, yes or no? I tried to trick you. That's good, you got it. So the answer is no, because it doesn't work for hourly employees, because you can't just say, hey, we'll just keep paying you while you're gone. But it does work for people that are exempt from overtime. Okay, this was an interesting statute. So 2 years ago, there were a series of studies done that determined that in public companies, right, the public companies that had female board members did better in a lot of categories. Interestingly enough, they tended to be more profitable. They tended to have a happier workforce. They tended to have a more diverse workforce. Okay, I can give you the statistics, but that's basically what it all said. So we implemented a statute that required these companies to start adding women to their board of directors. And we basically expanded on that statute this year by requiring that underrepresented communities also be on the board of directors of publicly traded companies. So what does that mean? That means by the end of 2021, every publicly traded company in California has to have one director from an underrepresented community. By the end of 2022, if you have 9 or more board members, 3 of them have to be from unrepresented communities. 2, if you have 5 to 8 board members, or 1 if you just have 4 or fewer directors, okay? Unrepresented or underrepresented, I think I should be more consistent in typing that out, means any individual who self-identifies as Black, African American, Hispanic, Latino, Asian, Pacific Islander, Native American, Native Hawaiian, Alaskan Native, or who self-identifies as gay, lesbian, bisexual, or transgender, okay? If you don't get that right, you will be publicly shamed. The state is going to publish the results of your reporting, and you will be fined. It's $100,000 for the first fine and $300,000 for subsequent violations, okay? What else has the legislature been up to? They have expanded our EEO-1 federal requirement, which is what I was thinking of earlier when I had a brain fart about the 300 OSHA form. But when you have 100 employees or more, you have to report certain data every year to the federal government. We now want that data to also be communicated to the Department of Fair Employment and Housing. It's going to basically give salary information and race, ethnicity, gender data for all of these people in different categories of jobs, and all for a certain snapshot of a single pay period. And why are we doing all this? We're doing all this because we're going to empower the Department of Fair Employment and Housing to investigate and possibly prosecute discriminatory wage complaints. So where they see a pattern where somebody is, or a specific gender, for example, is underpaid or underrepresented, the Department of Fair Employment and Housing has the ability to bring claims. More importantly, this is going to be public information. There won't be any individual identifying information, but there will be information about your company. So you want to make sure that you're doing your best to have a diverse and equally paid workforce. Okay, more public shaming. As of the beginning of 2022, when you file your statement of information, you have to report if any of your officers, directors, members, or managers have any outstanding wage and hour judgments against them. And we also empower our local state officials to enforce those statutes. And what else do we have? Consumer privacy rights. I'm just going to say real quickly that they've been extended out to January 1 of 2023 for your employees. So you don't need to worry about all of the required written notices when you're collecting information just for the sake of employment, of keeping track and monitoring and giving services and wages and whatnot to your employees. Don't know what's going to happen after 2023. New minimum wage requirements are in place, folks. You got to stay on top of it. You got to be paying $14 per hour if you have 26 or more. In the state of California, $13 per hour if you have fewer than 25. So that would apply in Beverly Hills. But if you're outside of Beverly Hills in certain areas, you may have a higher rate of pay. So in Los Angeles, for example, you're at $15 per hour now. As of January 1 of 2021, you will be at $15 an hour. And you will be even higher in places like San Francisco, where you're at $16.07, Palo Alto, etc. And there are new FMLA forms that you need to know about. I have given you the links right here. You can use those. Make sure you do not ask or cross out the specific health information question when you use it for the California Family Rights Act leave, because you're not allowed to ask that in California. And there's new COBRA notices that are available to you. This is where you find them. The new COBRA notices are here. Yes. And that's it, folks.
One question.
It's a lot to cover. Yeah, one question. Go ahead.
Okay. Has the California EDD advised on the following? Can employees over 65 who are in the LA Public Health Order or any other employees get unemployment if they are concerned about getting COVID in the workplace? Can an employer stop the employee from getting unemployment?
The standard still applies if you quit. If you quit your job because you're afraid of getting COVID, you would not be eligible for unemployment. But I mean, they were pretty loose about applying those standards for, like, there was independent contractors for a while there could get unemployment. So specifically, I can't tell you that that you won't get it, but I can tell you the standard is still in place. Anyway, lot to cover. Thanks for bearing with me. Those of you that are interested in this stuff, I do a newsletter and a blog that's pretty informative. If you want to be on the list, you can ask Blair, or you can send the information through the chat room, or contact me through LinkedIn or through my website. But hopefully I've answered all your questions. And if you have more, feel free to contact me. And thanks so much.